Imagine this. You are filing INC 22 for registered office change, INC 23 for shifting registered office, INC 24 for change of name, and suddenly MCA says, "Why use so many forms? Let's merge them." Yes, you heard that correctly. Several forms may disappear and completely new forms are proposed. But that's not all. MCA has also proposed increase in DIN applications from 3 to 5 directors, major changes in name reservation rules, easier Section 8 company compliance, new rule for deceased subscribers, flexible registered office verification, and one change could save professionals a lot of documentation work. Let's decode all important amendments in simple language. Hello everyone. Welcome to Corporate and Securities Law Compass. Because these proposed amendments can directly impact incorporation filings, registered office compliances, name approvals, and Section 8 companies. Let's begin. Part 1. Biggest change. Form consolidation. First major amendment. MCA wants to reduce multiple forms into just 2 consolidated forms. Think about the current situation. For different activities, we file different forms. Change of registered office, one form. Change of name, another form. Conversion, different form. Government approvals, different form. Now, MCA proposes ECHNG and ECON. Example. Suppose ABC Private Limited wants to change registered office, change company name. Instead of filing separate forms, MCA proposes a consolidated mechanism. Why is MCA doing this? Simple. Less duplication, less repetitive data entry, less compliance burden. This is directly aligned with ease of doing business. But wait, the next amendment is even more interesting. MCA is proposing a complete rewrite of Rule 8. And if you have ever struggled with name approval rejections, you need to watch carefully. Part 2. Massive changes in company name approval. Currently, many applicants face rejection because MCA considers names too similar. The proposed Rule 8 gives detailed illustrations. Example 1. Sunrise Technologies Private Limited and Sunrise Technologies Limited will be treated as same. Example 2. Blue Innovation Limited and Blue Innovations Limited will also be treated as same. Example 3. Next Gen Limited and Next Gen Limited same. Even punctuation, spacing, and special characters may be ignored. Let's test your understanding. If Express Delivery Limited already exists, can you register Express Delivery Limited? Answer: no, because pronunciation is substantially the same. This amendment provides much more clarity than earlier rules. Part 3. Trademark-related name restrictions. Here's where many startups make mistakes. Suppose ABC is a registered wordmark. Can you register ABC India Limited? ABC Delhi Electric Limited? According to proposed rules, generally no. Merely adding a city name or business description may not create distinctiveness. Practical lesson: before applying for a company name, always conduct 1. MCA name search, 2. Trademark search. Failure to do so can lead to rejection. Part 4. Huge relief for OPCs. Now comes a relief amendment. MCA proposes removal of affidavit requirement during OPC conversion. Question: why submit unnecessary affidavits if the information is already available electronically? This reflects MCA's move towards paperless compliance. Even Rule 7A relating to specific criminal liability provisions for OPCs is proposed to be omitted. Less paperwork, simpler conversion process. Part 5. DIN limit increased. This is a very practical amendment. Currently, DIN allotment at incorporation is restricted. MCA now proposes increasing the limit from 3 directors to 5 directors. Imagine incorporating a startup with founder, co-founder, investor nominee, independent director, industry expert. Earlier, additional processes could be required. Now, incorporation becomes smoother. Part 6. Registered office rules changed. This amendment will impact every professional. MCA proposes wider acceptance of documents. For owned premises, title deed, property tax receipt, municipal khata, utility bills. For rented premises, lease agreement, property tax receipt, municipal khata, utility bills. For co-working spaces, payment receipts, allocation letters, authorization documents. Example: suppose your startup operates from a co-working facility. Earlier documentation often created confusion. The proposed rule specifically recognizes such arrangements. That's a significant practical improvement. Part 7. Physical verification relaxation. Currently, professionals often worry about physical verification. MCA proposes a more risk-based approach. The registrar may conduct verification through an authorized person based on information available. This means verification becomes more targeted instead of mechanically applied. Part 8. New rule for deceased subscriber. Now let's discuss a unique amendment. Suppose 3 subscribers sign incorporation documents. Before paying for shares, one subscriber passes away. What happens? The draft introduces a new Rule 23B. The legal representative may step into the shoes of the deceased subscriber and pay the unpaid amount. This removes ambiguity that previously existed. A very practical legal clarification. Part 9. Section 8 Company. Relaxations. MCA also proposes simplification for Section 8 companies. Certain document requirements are proposed to be removed. Additionally, conversion from a Section 8 company limited by guarantee to a Section 8 company limited by shares is proposed to be permitted. This provides greater flexibility for non-profit structures. Part 10. Email communication recognized. One amendment every professional should note. Several provisions currently requiring registered post may now allow speed post and email communication. Think about the practical impact: faster communication, lower costs, better record keeping. A clear move towards digital governance. Conclusion. So, what are the biggest takeaways? Number 1. Multiple forms proposed to be merged. Number 2. Completely revamped name approval rules. Number 3. DIN limit proposed from 3 to 5. Number 4. Simplified registered office documentation. Number 5. Relief for OPC conversions. Number 6. New Rule 23B for deceased subscribers. Number 7. Greater use of email and digital communication. Remember, these are draft amendments. Stakeholders were invited to submit comments and suggestions to MCA. But if notified substantially in the present form, these changes could significantly impact incorporation practice in India. If this video helped you understand the MCA Draft Companies Incorporation Amendment Rules 2026 in a practical manner, like the video, subscribe to Corporate and Securities Law Compass, and comment below. Which amendment do you think will have the biggest impact on company incorporation in India? Thank you for watching. Disclaimer. The information provided on this channel, Corporate and Securities Law Compass, is intended solely for educational, informational, and knowledge-sharing purposes. The content is based on the provisions of the Companies Act 2013, SEBI regulations, FEMA, Insolvency and Bankruptcy Code, and other applicable laws, rules, regulations, circulars, notifications, judicial pronouncements, and professional experience available at the time of recording. The views expressed on this channel are personal and do not represent the views of any employer, organization, institution, client, regulator, or professional body with which the presenter may be associated. The presenter is a member of the Institute of Company Secretaries of India, ICSI. However, the content should not be construed as professional, legal, secretarial, tax, financial, investment, or compliance advice. Viewers are advised to consult qualified professionals before taking any decision based on the information provided in the videos. While every effort is made to ensure the accuracy and reliability of the content, no warranty or guarantee is given regarding its completeness, accuracy, or applicability to specific situations. The channel shall not be responsible for any loss, liability, or consequences arising from reliance on the information presented. This channel does not promote insider trading, market manipulation, unlawful activities, or any violation of applicable laws and regulations. Any discussion relating to listed companies, securities markets, corporate actions, or regulatory developments is purely for educational and academic purposes. By viewing this content, you acknowledge and agree to the terms of this disclaimer.